All right, so as we are video conferencing today, I would like to introduce you to the members of the committee who are participating in the hearing. So I'm Dr. Katrina Stratton. I'm a member of the Legislative Council and the chair of the Legislation Committee. Tim?
Tim Clifford, member of the Legislative Council.
Rod Caddy's member of the Legislative Council.
Lauren Cayoon, member of the Legislative Council.
Simon Ehrenfeld, I'm the Deputy Chair and a member of the Legislative Council.
And we also have recording staff, and the committee's advisors are here with us today also. The committee acknowledges and honours the traditional owners of the ancestral lands upon which we meet today, the Whadjuk Noongar people, and we pay our respects to their elders, both past and present. Before we begin, if you could each in turn please state your full name and the capacity in which you appear before the committee. So we'll begin with you, Mr. Fitzgerald.
Thank you, Madam Chair. My name is Paul Fitzgerald. I'm the State President of the Sporting Shooters Association of Western Australia and the National Senior Vice President of the Sporting Shooters Association of Australia.
Thank you.
Good morning. I'm Murray Bowe, the Vice President of the WA Shooting Association.
Thank you.
Ralph Foley, President of the WA Shooting Association.
Thank you.
Steve Harrison, I'm the State Advocate for Shooters Union in West Australia.
Good morning, Madam Chair and committee members. My name is Royce Wilson. I am the National Media Director for Shooters Union Australia and supporting Steve.
Sorry, what was your surname?
Pardon?
Royce.
Royce Wilson was my
Wilson.
surname, one L.
All right, so thank you all, and I now require you to take again in turn either the oath or the affirmation. It'll be there in front of you.
I sincerely declare and affirm that the evidence I will give before this committee will be the truth, the whole truth and nothing but the truth.
I swear by Almighty God that the evidence I will give before this committee will be the truth, the whole truth and nothing but the truth.
I swear by Almighty God that the evidence I will give before this committee will be the truth, the whole truth and nothing but the truth.
I swear by Almighty God that the evidence I will give before this committee will be the truth, the whole truth and nothing but the truth.
Thank you.
I sincerely declare and affirm that the evidence I will give before this committee will be the truth, the whole truth and nothing but the truth.
Thank you. And again, in turn, you have signed a document entitled Information for Witnesses. Did you read and understand that document?
Yes, I did.
Thank you.
Yes, I did.
Yes, I did.
Yes.
Yes.
Thank you. These proceedings are being recorded by Hansard, and a transcript of your evidence will be provided to you after the hearing. Please note that this broadcast will also be available for viewing online after this hearing, and please advise the committee if you object to the broadcast being made available in this way. All right. Do any of you have an opening statement that you wish to make?
If I
All right,
may,
we'll
yep.
start with you, Mr. Fitzgerald.
Thank you. I'll be as concise as I can.
Thank you.
So thank you, Madam Chair, and thank you to the members of the committee for providing this opportunity to bear witness in today's hearings. I speak to you today in my role as the National Senior Vice President of the Sporting Shooters Association of Australia and the State President of the SSAA and WA. 80,000 law-abiding West Australians with a firearm licence and the thousands of civilian sporting shooters, landowners and those with the need to legally own and use a firearm across the country are pleased to see the parliamentary process being allowed to function as it should with this review of the WA Firearms Act 2024. We sincerely respect the time that the members of the committee have dedicated to this review and thank you for your commitment to interrogating what is now widely accepted as the last piece of legislation that should have ever been rushed through the WA Parliament. The Sporting Shooters Association of Australia, as a bit of background, was first established in 1948 and the West Australian body was formed in 1971. Many of our members that I represent today have been with us since inception and have remained part of the law-abiding firearm community since the introduction of the Firearms Act in 1973. Our organisation has witnessed and has been forefront in the narrative of the changing landscape of firearm legislation for over 50 years. Our intricate knowledge base and understanding of the history of firearm ownership in WA remains unparalleled. Created by volunteers with a passion for recreational and sporting pursuits, the organisation remains a registered not-for-profit association and is largely run by volunteers at club, state and national level. With respect, it is worth noting that many of the witnesses from some of the organisations that have appeared before the committee are paid professionals with a limited first-hand understanding of firearms, mostly having never owned or used a firearm. With the current membership in Western Australia of over 16,000 licensed firearms owners and over 200,000 members nationally, the SSAA is recognised as the second largest shooting organisation globally and understands at a micro level the complexities of firearms in the community. Recognised by the WA Department of Creative Industries, Tourism, Sport as one of 90 state sporting organisations, we manage and foster over 20 internationally affiliated competition shooting disciplines, conduct accredited safety training courses, manage approved shooting ranges and educate the greater public on the safe use of firearms. Our members and our organisation are major contributors to the safeguard of native species in Western Australia as part of a number of long-standing pest management programs in the private and government sector. And we provide the largest number of approved shooting facilities at over 60 clubs and ranges in Western Australia. Competition members are provided with dedicated pathways to state, national and international representation in the ballistic sports, with training, funding and coaching largely self-funded by the members. It is important to recognise that competition shooting, ethical hunting and the recreational use of firearms have been part of the West Australian landscape for over 100 years. Every individual SSAA member is protected by the Association's nationwide $20 million public liability policy that ensures the safety of both licensed firearms owners, landowners and the greater public whenever our members are using their firearms for sport, work, competition practice or hunting. SSAA Western Australia was and remains a cornerstone stakeholder in the creation of the WA Firearms Community Alliance, created in a symbiotic approach to bring together the respected and long-standing WA-based shooting, farming and industry organisations. Formed in 2023 to provide a cohesive voice and a dedicated representative body for the WA Government to consult with, we have endured various barriers and a lack of real listening from the previous Minister for Police following the announcement of the rewrite of the Firearms Act in March 2022. SSAA WA, the WA Firearms Industry and our WA-based state sporting bodies have also been engaged with numerous state governments as far back as the Law Reform Commission in 2014. This is not something we do as a volunteer organisation for the media headlines or because it's the hot topic of the day. SSAA have been at the forefront of the need for firearm reform in Western Australia for over 10 years and have provided a sound and mature voice for regulators and legislators to engage with from the community. I trust the evidence we provide to the committee today is received in good faith, with the sole intent of the SSAA to contribute to this review respectfully and ensure the ongoing safety of the community with respect to licensed firearm ownership in Western Australia, whilst providing practical, sensible and achievable outcomes in the repair of the legislation for not only this generation, but the next generation of licensed firearm owners to come. Thank you.
Thank you, Mr Fitzgerald. Either Mr Foley or Mr Bowe. Yep.
Thank you. The West Australian Shooting Association, known as WASA, represents licensed firearm owners in WA through its members, Conservation Australia, WA Field and Game, both groups active in feral animal control, assisting WA landowners and government departments. Shooters Union, representing any WA licensed firearm owner, the IPSC, WA's Practical Pistol Shooters, the West Australian Pistol Association and WA Small Ball Rifle Association, who are both members of their national associations and Shooting Australia. These associations, along with the WA Rifle Association, the Clay Target Association and Sporting Clays WA, are the pathway associations for shooting athletes to represent Australia in the Commonwealth and Olympic Games as other worldwide events. It is significant that 3 of our member associations have been asked with us to appear and answer questions from the committee: Conservation Australia, WA Field and Game last week and Shooters Union today. We will assume the committee has considered our and our members' submissions, and it isn't our intention to present them again. We endorse our members' submissions and invite questions that you may have on any topic in our submission, but particularly related to competition shooting. I'm a coach of shooting athletes, a committee member of the WA Pistol Association and council member of the National Association Target Pistol Australia. Thank you.
Thank you. Mr Harrison.
Thank you very much. As previously stated, I'm the West Australian Advocate for Shooters Union WA, and I've held the role for approximately 4 years. Shooters Union WA represents the interests of all responsible firearm users in the state, including hunters, target shooters, primary producers and occupational users. You don't have to be a member of Shooters Union WA to ask for our support. We maintain an open door policy. Shooters Union WA is of the opinion that 2024 Firearms Act and accompanying regulations have the deliberate intent to remove most firearms from private possession in WA, and further that the legislation, regulations and licensing portal are not fit for purpose. It's obvious that the intent of the legislation is to make it as hard as possible for private members of our community to maintain a firearms licence. Shooters Union WA is of the view that the supposed consultancy prior to and while drafting the legislation was both selective and, unfortunately, secretive. It's also our view that it was a deliberate effort to preclude the largest firearm owners group, where that is recreational hunters, or now hunters' licences, from active or direct involvement in discussions. We believe the intent was always to target this group and reduce their numbers. A general view is that the regulators were ill-informed as to which stakeholder groups should have been engaged as part of the consultation discussion, and that is a significant comment from our position. There is no credit given or acknowledgement expressed that the majority of firearm owners are safe in the management of firearms, have previously been deemed fit and proper persons, and that they are and remain law-abiding members of the West Australian community. In respect of your reporting scope, I've summarised some commentary. The first one is problems that have emerged from the implementation and operation of the legislation. My first comment, I think you would be very much aware, is that there are too many to refer to in the brief time allocated today. Suffice to say, the legislations and regulations are simply a muddy pool. And I think Paul Cook from Conservation Australia alluded to exactly the same thing when he said he read the legislation and had some difficulty interpreting it. Implementation has created confusion, anxiety, emotional illness and final loss to firearms owners statewide. And I can tell you that Shooters Union has been supporting some people with extremely high levels of anxiety, and predominantly people of significant age, people that just use 22s at a club for sporting and recreation. So we're quite happy to represent those people. The buyback program is configured as part of a scare campaign to encourage the surrender of firearms while offering token compensation. Further belief is that it sits on the precipice of compulsory acquisition due to the economic and practical realities of lawful firearm sale or disposal from Western Australia to the balance of Australia. Market disturbance as to commercial values directly relates to the harsh mechanisms of the Firearms Act 2024. So what I can tell you is that the value of pre-owned firearms in Australia has now been demolished, straight out of the Act. A landowner's right to consent to and allow shooting activities on their property is substantially curtailed, which in effect reflects unwanted government control of private property. Licence categories are inconsistent, where a hunting licence holder can use firearms on open land and on an approved club facilities, and as far as we understand, a competition licence does not provide a reciprocal authority, which we consider may result in a firearm owner requiring two identical firearms in order to undertake the chosen activities. Item 2 on your list of things to do, whether all provisions are consistent with fundamental legislative principles. So we took a broad view in respect of this, and I'll say, if the fundamental legislative principles in Western Australia aim to ensure legislation is well drafted, respects individuals' rights and upholds the principles of parliamentary democracy, very little of the West Australian Firearms Act 2004 and accompanying regulations comply. It's our belief that the entire effort in generating legislative change was pushed by what we have no doubt to be a personal agenda. We further believe this bad faith push to ram this legislation through was aided by a media which mostly appeared to uncritically support the government narrative. Item 3, recommended amendments that will ensure the legislation's workability and effectiveness. So this has been said many times, and you may have already heard it several times. One of the recommendations that we would suggest is put forward is that you incorporate the recommendations of Project 105, the review of the Firearms Act 1973 WA undertaken by the Law Reform Commission of West Australia. Also, align WA legislation with that of other states to create national consistency for firearms licence holders, in particular the recognition of all other licences. I'm getting there. Form an inclusive consultation group to assist and advise on the real world use and possession of firearms within Western Australia for the purpose of review and generation of alternative and corrective legislation parts of the Act. And I've got a breakdown here which goes to my point on the earlier comments on consultation, and that is that the compilation of any consultation group should be around about 50% hunters and collectors, 20% competition associations and clubs, 20% agricultural sector, and 10% commercial and government interests. That would have provided a much better outcome to the legislation had that have been in place from day one when the Act was being written. So the wrong people got in, the right people didn't get in. That was the problem. Okay, thank you very much.
Thank you. So before I ask my first question, I just want to respond to a couple of things in there. So I will reassure you that the entire committee have read your submissions. That's part of our responsibility and our due diligence as committee members. And so the questions that we ask will be wanting to either clarify or ask you to expand on what is in your submissions. I also want to be clear so that we can make the best of the time that we've got. It's not within the committee's terms of reference to examine the process under which the legislation was passed. We have heard a lot about that in the submissions, and we appreciate that, but it's not within our terms of reference. Not only is it not within our terms of reference, it's not actually within the Legislation Committee's responsibilities as set out by the standing orders either. So I'll just invite you to make the best use of the time that we do have available with regards to that as well. So if I could start, so we have had other witnesses who have suggested that the minimum age for firearm use should be raised to 18, and I'm just wondering about what the implications might be for that for people who engage in competitive shooting and particularly elite shooting. And
I'm happy to talk to that, Madam
you.
Chair. So part of our submission does reference the junior licence category, and during consultation it was originally envisaged that there would be a junior licence category. We haven't had a minimum age in Western Australia for young people to be able to legally use a firearm under the supervision. And just so that it's clear in the committee's mind, it's always been the case that an individual in Western Australia needed to be 18 and over to apply for a firearm licence, as opposed to accessing or using a firearm under the immediate supervision of the licence holder. So there's no suggestion that the age of a licence holder should be reduced. But of course, like all recreational and sporting activities, we have young people that enter into the sports. And we now have a minimum age that says nobody in Western Australia under the age of 12 can touch a firearm. What we are failing to see in the construction of the Firearms Act and the regulations is in every other state and territory there's an ability for a young person to go through the system, if for want of a better word, and be classified as a person or a young person that can have a permit or a authority to have possession of that firearm for a competition purpose. The business that we currently faced is the licence holder has to be immediately with that person. So in the case of a father-son or mother-daughter, even if that person enters the ballistic sports in Western Australia, does very well at their local clay target club, 12, 13, 14, 15, because there's no formal regulatory structure for that person to have a permit or an authority, if they travel to another state, they can't use a firearm because you must have a permit, a junior permit or a junior licence. It's readily available on the New South Wales Police website, the Tasmanian Police website, Victorian Police website. So that's a huge restriction. It was originally put forward, but then for whatever reason it was removed in the final construct of the Act and the regulations. So there is an argument from the other side of the regulator that juniors can still use a firearm under the immediate supervision of their parent or under a corporate licence in a competition shooting environment. So the club may hold a corporate licence and may have some firearms that people can use. But that still doesn't resolve the problem of a young person being 15 or 16 years of age and winning the state titles and then travelling interstate and going through those pathways to continue to use the firearm. They could not go to Queensland and go to an approved gun range and use a firearm because they don't have a permit or a licence. There is no danger to the community because that young person under the age of 18 is not permitted to possess the firearm on their own. They just have a licence that says that if they go to another location, a person or a corporate licence can allow them to use the firearm. So that's the failure of the construction for the junior licence category, severely limiting young people's entry into the sport. They don't get to take it home and put it in their own gun cabinet.
Okay.
I hope that's clear.
Yep,
If that makes
no,
sense.
that's good. Thank you.
Madam Chair, could I add to that as well?
Sure.
Reiterate everything that Paul said there. He's obviously a little younger than I am. I remember when it was 16 to
So I
obtain a
got
firearms
mine when I was
licence.
16, but I didn't want to tell the committee that.
And I don't think we have a question. There's no problem with being able to obtain a firearms licence at the age of 18. That is what it is now, and it can remain at that. The issue for our competitive sports is juniors they cannot get access to a firearm unless their parent either owns it or the club owns it. And the difficulty we are facing, adding to Paul, is the requirement for the supervising licensed firearm owner to have held their licence for 5 years before they can supervise. So a junior at 12 can come into our sport. Previous to that, there was no age limit. In my own club, we had 10-year-olds shooting, some who had to stop in March and then restart shooting when they turned 12. We currently have a 12-year-old who turned 12 in March of this year, who is on the verge of being in our state team, our junior state team at that age. He started shooting with our club when he just turned 11. So this is creating a problem, and it's the supervision of these juniors by their parents who haven't had a firearms licence for 5 years. And that's not just in the WA Pistol Association, it's in all competitive shooting sports.
And further to that, there's no matrix about why that's been constructed.
Yep.
We did ask the police about how they came to that point. What is it that somebody has to satisfy over 5 years as a licence holder? And they couldn't provide us any backup on that.
Yeah,
Right.
now, it's all right.
Yep.
Because you said you're a coach.
Coach,
is it
yes.
right? Yeah, and I guess Mr. Fitzgerald could add to it as well. Now, I've seen that 70% of the parents wouldn't have had this is what was provided to me. I don't think it's in the report, and I just want to check and make sure. Is that going to have effect on a large percentage of the junior shooters, that 5 year thing? And as a coach, what level would you say is 5 years reasonable or not, or is it 1 year or 3 years, or when do you think a parent? How long do you reckon would be appropriate as a shooting coach for someone to be of have the experience and skill set to be the right person to be overseeing a young person?
I think it should be based on competency, and it always has been. In our club previously, if we were going to supervise a new shooter, an unlicensed shooter, or a junior, it was a competent club member who had been trained could supervise them. Now it's arbitrarily put into the legislation 5 years. Now someone could have left their firearms in their safe for 5 years, and their junior starts, they're competent, supposedly, to supervise.
So you think a club that whoever's the overarching person who is assessing the competency of the firearms owners would be the best suited to decide. So you just think anyone who has been deemed competent as a firearms shooter at a club, it would be the right person to oversee. It shouldn't be a 5 year thing.
Most certainly, I don't think it should be an arbitrary 5 years. It needs to be competency. Previously, clubs decided and assessed their members and trained their members, so it was always a trained person. You wouldn't have a firearms licence if you hadn't been trained. So 5 years, I don't know where that figure came from, and it is certainly far too high.
So would that put any, would that put any burden on the club? Because we have heard in other submissions about and appreciate this is separate, like the administrative burden. And so if we're asking the club to then assess competency, is that something you're already equipped to do, or would that be an additional burden?
It's adding a burden, especially to me as a coach, because I can't even supervise a junior athlete whose father or mother owns a handgun because I'm not licensed to that handgun. So if mum and dad bring their junior down with the handgun for training, I can't supervise him with that gun. He has to then hire a club firearm and use that which I can supervise. We're getting to the extent now where our junior parents are purchasing firearms to put them on our club licence just so their juniors can continue shooting.
So the ability or otherwise to share firearms in the confines of a club or the context of a club, that is an issue.
It certainly is, because it was never a problem. We were always aware that the previous legislation in 73 didn't allow the sharing of firearms when you were over the age of 18, but on an approved range and within a club, you could share firearms. And there were many stories in our submissions about athletes, senior athletes, who break national records borrowing firearms. Now, they can't borrow a firearm if they want to continue in that discipline, need to purchase more firearms. That's then limited by the number and the cap, which is a whole issue that we should talk about, but may not have time.
If I may add to that, Madam Chair, if we just come back to the training question from Mr Caddies, the construction of the Firearms Act and regulations now has some increased training requirements with a much broader practical and theory assessment for a new applicant. So mum or dad decides to join a firearm club and they're over the age of 18 and they need to obtain a firearm licence for a target rifle. So the regulations and the legislation have already, that person satisfied those tests of training and practical assessment so that they can be sent out into the community, whether that be hunting or competition, and they're supposed to be deemed competent by WA Police because they've passed through the gate and they've said, Mr Caddies, you're a suitable individual and you've passed all the training. It's constructed in the head of power in the Act. So they then come in and say, you're capable, but you're not capable to instruct somebody else as a junior, and moreover, your own children at an approved shooting range, is kind of lost in, are we undermining what the training's doing? Because we've got this new training regime for firearm licence holders. The club competition environment has always self-regulated itself, that they don't just get this brand new person show up and send them off to be fundamentally what is a range officer or a person who is legally responsible for the conduct of affairs at an approved shooting club. What we're talking about here is, irrespective of, that person cannot use that other firearm under the immediate supervision of the adult licensed parent with the coach standing nearby because the person hasn't had that firearm licence for 5 years. So it's a little bit messy and there's been no explanation as to how that's come about. If I, again, coming back to the training, if I wanted to get a forklift licence, I would go and be trained to get a forklift licence, how to drive a forklift, then I would do a test. What we continue to have in the West Australian Firearm Regulations and, the Firearms Act is, here's the test. So log on to the TAFE, here's your test, do the test. There is no training, it's just a test. So it's still back to front. People are not actually getting any real world theoretical training, they're just having to pass a test. Okay. Now, the argument may come about that they could refer to the National Firearms Safety Training booklet that was developed as part of the National Firearms Agreement. But there is no pathway for people to understand that I should probably read that first, and then I should, if I really want to pass the test, this is the old firearms regulations, this is the new one. So your regular West Australian citizen has a requirement to get a firearm licence. All of us in this room are struggling to grip up all these pages. Your average punter's not going to grip them up either. So we put these hurdles in front of entry, or barriers to entry, for young people that want to enter into the ballistic sports and competition, because we have these non-explained reasons about why they can't do that.
Mr.
Chairman,
Harrison.
just not to
Sorry,
labour
I'll
the
just go to
point.
Mr. Harrison first.
Just taking this to a much higher level, which will, I think, assist the committee to substantially. Should someone less than 18 years of age have a firearms licence, was the original question, I understand it. There's no reason why someone at 16 couldn't have a permit for the purpose of interstate competition, so that provision could be there. It doesn't need to be a permanent licence, it could be a permit. In respect of firearms at the range, if it's an approved range, and if the coach or the mentor at the range is a person who ordinarily qualifies and has qualified for a calibre of the type and style of the firearm that the other person is using, there should be provision to allow him to lawfully maintain contact with the gun and the person involved for the period of time they're at the range. So you don't need separate licensing categories. You just need to empower someone on that range. It'll be a range officer, it'll be an executive, whatever it is, and they will be there because they have to be there.
Well, not necessarily.
Well,
no.
hang on, Paul, just hold fight, mate. So there is a much easier way of doing that, and I would suggest that it wouldn't take a great deal of manipulation of the actual regulations to allow that to happen, and it solves the problem.
Okay. Do you have
Chair,
anything additional?
Just on the 5 year, we've just had a newsletter from the WAPOL consultative group that can't be changed. It's not at the discretion of the Commissioner. He cannot alter that because it's in the Act. And this is something I think that the committee would appreciate, and this is what this review about, is which parts of the Act could or should be changed. This in particular, the Commissioner has said, I have no discretion, 5 years, I cannot change it.
Okay. Mr. Foley?
Yeah, look, I'm afraid that any time frame on a competency is absolutely garbage. Someone could be in a club for 5 years and attend once or twice, and you could have, and then after 5 years they get deemed that they can be the supervisor. On the other hand, you could have someone that comes as a firearms instructor from the police force or the military. They bring that experience across. Why on earth would they have to be in the system for 5 years to qualify? It just does not make sense. It's not in normal industry standards. It's, as someone's mentioned here, should be based on competency, not time. Time is absolutely irrelevant. So stupid.
All right. I think we're clear on that point. Simon?
Yeah, thank you, Chair. So firstly, let me just clarify. The Sporting Shooters is an association of individual members, and the Shooting Association is represents associate bodies. Is that
That's right. It's an association really of associations.
okay?
We don't have individual people as members.
Okay, all right. So, and it sounds like the bodies that you represent cover different areas. We've been trying to segment our committee hearings. This is more focused on sport shooting, but we have one on conservation and other areas, and you've had members in other hearings, you've said.
That's right.
So,
We've been fortunate because
Yeah.
our membership is wide.
Okay.
It extends from recreational, feral control to competition
Yes.
shooting, and they've had appeared before the committee. The competition shooters are the ones that haven't had the opportunity to appear before this committee.
Right. Okay. No. Thanks for clarifying that. So one of the things that seem to come through the submissions is this whole notion of people's rights being violated and not having proper legal processes and so forth. And I mean, I don't need to refer to particular examples, but what we are trying to get out of today are the absolute key parts of the legislation that what's the number one thing that you would like to see fixed. I know to read through the submissions you'd almost like the whole lot redone from scratch. Assuming that won't happen, what practically do you think can be done? And I'll open that to all of you. That would also be likely to have what I'd regard as public support.
If I may, through the chair, kick that off. If you ask the average person with a firearm licence, or even people without a firearm licence, what some of the concerns are about, and particularly from the SSAA's point of view, there is no argument about that we need to make sure that firearms are secured in the community. Simple as that. What we found with the storage matrix is that there are some huge complexities about occupied and unoccupied premises, and people have two firearms and they're at an unoccupied location, which could be a shed 50 metres from the occupied premises, and they're now having to suffer the burden of purchasing a new firearm cabinet. So for as many years as it's been required, the thickness of the cabinets has been 2 mil in the body and 4 mil in the door. As a minimum now, we're at 3 mil and 6. And people are having to suffer that, and the government's put themselves into a liability by forcing people to pick up the storage matrix. More so, you've got families that live at the same residential address. And so they're suffering the numbers of firearms at a single address. So Mr Clifford could have 3 firearms and he could be the son of Mr Caddies and he has 5 firearms. All the firearms from both licence holders at the single location now need to upgrade their storage. If Mr Clifford was Mr Caddy's son and he moves out, Mr Caddies is left bearing the burden of the increased cost to upgrade his storage, as opposed to every individual licence holder is assessed and every individual licence holder is subject to numerical limits, and the storage matrix has been constructed around numerical limits. But if you put individual licence holders in the same location, everybody's matrix goes out the window. And that has been a huge financial impost for a lot of firearm owners. And it doesn't really increase community safety. We already had an acceptance of the storage facilities that we had because the government said if you have less than 5 firearms, we'll accept, if you never re-enter the matrix, that your storage facilities are grandfathered. So if I have 5 firearms and I never re-enter the firearm purchase or change, then that cabinet that I've had for the last 20 years is satisfactory. But if my child comes up through the ranks and then there's 6 firearms stored at that address because they've turned 18 and got a licence, then there's 6 firearms at that address and everybody's got to get compliant. So that occupied, unoccupied needs some work. It may be difficult now because we're 4, 5, 6 months down the hole and a lot of firearm owners who all want to be compliant, which is one of the big key things about this, have already spent a lot of money to upgrade their safe storage in the confusion of, do I need a new cabinet? I'm a farmer with 2 guns. The firearms, and I've witnessed some of the other hearings, the firearms are in the locked workshop, but because I don't sleep next to the gun cabinet and I'm a farmer or a landowner, I need to upgrade my gun cabinet to a new gun cabinet because I've got 2 firearms. So that is a huge issue about the storage. The SSAA are not suggesting that storage and safe securing of firearms is not the top of the list, but it's a huge issue. One of the other key points, Mr Ehrenfeld, that I would like to point out to the committee, excuse me, is in accordance with the Law Reform Commission and one of the 143 recommendations, the reinstatement of recreational shooting as a genuine reason. We do have a large cohort of firearm owners in Western Australia who don't want to compete at an approved shooting range and they don't necessarily want to hunt and kill animals. They want to use their firearm like they have for the last 30, 40, 50 years for recreational activity. Now that could be buying a small property, getting themselves a clay target thrower, getting themselves a shotgun and shooting the clay targets at their $1 million property in Bindoon. There is no premise in the header power of the Act to allow that to happen anymore. It has always been in the previous Act that you could make application to get a firearm licence in Western Australia for competition or recreational shooting or hunting. But we've pulled that out because apparently it's making the community much safer now, which is why you've seen people being forced into gun clubs and you've seen the gun clubs bursting at the seams and you've seen all the concerns about people being able to get a hunting authority because lots of landowners were quite happy for people to come and do recreational shooting at their place, but now they have to say they're going to kill something when they come there. And not everybody that has an interest in using a firearm in Western Australia wants to shoot competitively or hunt animals. It's in the head of power. So if I'm a realist, I don't think that the Act is going to be opened up to reinstate that genuine reason as one of the pillars of firearm ownership in Western Australia. But it is something that really does underpin why people have firearms and why they've had firearms for some time.
Okay.
They're my
Thank
2
you.
points. Thank you.
Can we move on to the WA Shooting Association to answer Mr Ehrenfeld's question?
Okay.
Oh, sorry.
Sorry, I was going to just say that
If it's already in their submissions, you'd think if it was most important, it would already be in there. Could
Yeah.
we be digging down on questions?
Yeah.
Well, no,
true.
but they've got lots of things in their submissions. I want to hear from them. What's your
but-
number one?
I think we do have to be really cautious of the time
Yeah.
that we've
I
got.
can give short answers.
as
I'm going to
my,
cut off my VP here and speak.
as my learned colleague has pointed out, we really do want to hear new information or be able to clarify.
Yeah, because there's things in the
Things.
submissions that I think, like, another example is like, people were talking in, I think it was the
Sorry,
Pistol Club.
I'm sorry. I just asked for what their number one was. I didn't ask for a long answer. I've only heard Mr Fitzgerald's number one. I'm happy to move on. I accept that Shooting Association represents these other bodies.
Okay, so
I'd be
perhaps
happy
if
with
we
one
could
more
hear
brief
briefly
answer.
what your number one is, and then we'll come to.
Okay, the number one thing that we'd like to see in this legislation is fact-based legislation. So legislation backed on facts. We note that there's been a decline in firearms crime from licensed firearms owners, but this has not been acknowledged.
Okay.
That's the first point. Now, the Law Reform Commission did a very extensive report, and that report was fact-based. We would like you to refer to that report. The other point I would like to make, which is a little bit sensitive, but I'm going to make it anyhow, the recovery rate by police of stolen firearms is about 15%. So 15% of stolen firearms are not recovered. That is a public safety issue. There's been nothing in this conversation that has said we're going to give greater resources to the police, and the Commissioner tells the police, the Police Minister tells the Police Commissioner, your recovery rate needs to be 100%. You need to get those stolen firearms from licensed firearm owners like us out of the criminals' hands. So they're my 3 points.
Thank you. And sorry, before I throw to you, Mr. Harrison, can I just clarify again that it is not in the remit of the standing orders for the Legislation Committee, or indeed our terms of reference, for us to examine or comment on the process under which this legislation was passed. So with
I'll be as brief as I possibly can, Madam President. To answer your question, from a top of the list requirement or request for change is the way in which private property owners can issue permissions to people for the purpose of hunting on their properties. So Western Australia is a massive, massive place. Some of the properties are so big it would take you 2 months to walk from one boundary to another. Yet if that person doesn't register on the portal, then they can't provide a firearm authority or an authority for someone to carry and use a firearm on their property. That is just ridiculous. It's absolutely ridiculous. So it needs to be opened up. If someone owns a property, corporate or otherwise, and they have a pest problem that they managed, and there are plenty of those opportunities out there, they should simply be allowed to issue a permission for someone to go onto their property and destroy those pests. That is something that's been happening in Western Australia forever. It's now just changed. There was no indication that it was a problem previously. Thank you, Chairperson.
Thank you. Thank you. Rod, I'll let you ask your...
It's just because it's in the submissions about things like first aid, needing first aid at shooting ranges and that. And I read in one of the submissions about how, if you're a professional competitor, you might be training 6 days a week, and to the resources needed for each place that people are going to is quite expensive. And is that a real major issue for you guys as far as the first aid people attending to be there all the time when anyone's on site?
Could I make a comment on that? And and this comes back to what are the major, if we could change one or two things, and the range requirements for an authorised person, which used to be just a club trained person. Now it's an expense to the club to have someone authorised to be there, and a first aid qualification. You can't shoot on a range without either one or two people being there, and if you're an elite or even a club shooter wanting to train any day of the week, where you could go to a range and do it safely, there was no danger to the public, you can't do it anymore. Remembering that ranges are run by volunteers, and they can't be there, and it is restricted. Clubs that I know within the pistol shooting fraternity and the other competitive sports, where they can only open their ranges at set times, and this is limiting our training. And WA have world-class athletes. They have world record holders. They have there's 2 pistol shooters just returned from the Australian, the WA 1500 World Championships in Germany. And they want to train 6 to 7 days a week, and they are limited.
So if I get a hunting licence, or I'm a primary producer and I get a firearm and I head off into the paddock, I don't need an authorised person, a range officer or a first aid officer to walk beside me. If I go to one of the safest places to use a firearm in Western Australia, even in a layman's point of view, which is a firearm range with standard operating procedures, one direction to squeeze the trigger only, why is it all of a sudden that we need to have all these layers of regulatory people? That is an impossible task in Western Australia. We have regional clubs in Parabadoo and Tom Price, people that go down there, 3 or 4 people or one person on their shift. It is an impossible task. It has been given no matrix about why it's been introduced, that we have to have a first aid officer, an authorised person, a range officer, when for an eternity, individual, fit and proper people who have joined a gun club, have a licensed firearm, want to go and practice at the Parabadoo Gun Club on a Tuesday afternoon and follow the standard operating procedures of the club, shoot the targets in one direction. There is no need for any of those other things. Makes no sense.
Thank you. Just got a couple of questions that I've asked in some other groups as well. One of the things that committee members have heard in submissions and in hearings is that there has been misinformation that has circulated that has potentially confused people's interpretation of rules and created some angst in different sort of shooting communities. Some have suggested that perhaps that might be a result of information being put out by different groups or by different people sort of going to different sources of truth to get that information. So I just wonder, in your experience, where do sort of people in your communities go for that sort of trusted information? Is it Waypol? Is it Facebook groups? How is that information sort of being circulated?
It's a little bit of both, to be honest. Firearm owners, by and large, by their nature, are not big at having a big sticker on the back of their vehicle or a big red flag saying, I'm a gun owner. So they are hard to get hold of. We find that in the Sporting Shooters Association. We have lots of members. Some of them want to be contacted all the time and some don't. WA Police have actually done a very good job with their information sheets that they've put out, even though they have changed them on the fly. So, you know, we already saw the first tranche of regulations change on the 3rd of February. So some of those information sheets were released, and then very quickly we saw red lines get put through some of those because the regulations were changed. So I've heard the suggestion that WA Police should have come out with a bit of a booklet that they could have posted out instead of this great big pack with all this information that tries to cover every scenario. It is fundamentally 3 things that are being asked of firearm owners. Accept the digital licensing system, which, you know, the mature organisations have asked for 20 years. So people need to get digital. We need to move away from paper licence. Satisfy the regulator that you have some safe storage to put the guns in, and tell us that you've got somewhere to use the gun. So some people might accuse me of being sympathetic to the way that WA Police have approached that, but they are essentially the 3 things that they're asking for. And if they had managed to grip that up and communicate that to 80,000 people in the form of a simple electronic communication and not come across killing ants with sledgehammers, which is what they've fundamentally been signalling to the firearm community, you will do this, otherwise we will enforce this. That's not how you engage with what are a huge part of the West Australian community who, by and large, are the licensed, law-abiding people. If you threaten anybody, it doesn't augur well. You don't get much good positive feedback. And I think the temperature's changed a little bit with the way that the police are engaging with people. They're throwing a lot of money and a lot of staff and the licensing services in Cannington. I don't know that, to be honest with you, this far down the track, we're about to enter the 3rd tranche of people needing to go through transition this year. And I think the horse has probably bolted on how WA Police impart that information. I think they probably set all this in motion and they've been chasing their tail ever since. I'm not suggesting it couldn't get better, but I don't think we're going to come up with some magical Bible that we're going to hand off to firearm licence holders. Moving forward, 100%, because this is not the transition year. This is the next 50 years. All things being equal, we're not going to see the Firearms Act change for another 50 years. And the new people coming into it need that information. We still have existing licensed firearms owners thinking that if they need to transition in the digital year, that they need to go and do a health assessment. It is the number one question. I've got a firearm licence. I want to get renewed I have to go and see the doctor. That's not the case in the transition year, because this is not renewal year.
With the new legislation, it is confusing as to who can provide the most accurate information. We all understand the legislators make the legislation, the executive set out the regulations. One of the real problems in this is that the regulations, there are so many substantive regulations which should be in the Act, it's making it really confusing for the layperson to understand. If you want information you want to understand about owning a firearm, you should read the Act and check the regulations. I think that is even making it more confusing even for the regulators, because the information we get from the regulator on a daily basis, feedback from our members, is that they were told one thing today, another member is told something completely different, and I could verify that personally. I could give examples. We don't have the time, and I don't want to waste
If
that
you
time.
could give us one example, that would be helpful. Like, who other than Waypole are people seeking that kind of advice from?
Well, club members come to their associations looking for answers. The associations generally turn to the regulator to get an accurate response. It takes too long to get that response, and the response is different. And I think it comes back to these substantive regulations. There are too many of them, and it is difficult for even the layperson, when the regulator has difficulty instructing their staff to give the same answer to the same question to an organisation who can relay it back to their members, and that is the difficulty.
Okay, so you're getting so even when you go into Waypole, getting different information from people within Waypole, or getting different information from different sources?
Getting different information from different people within Waypole, and I can give you an example. Authorised persons. We were told several times in meetings with the WA Police that if you were an authorised person under any licence, it would be transferable. The authorisation could be used at any licence club at any licence range. First time I personally tried that with a member of our club who was an authorised person with 2 different licence holders. I was told, no, go to the portal, make an application process. I said, no, we were told an email. Several bits of email correspondence where it was rejected, and then I received it in the mail. The first information was correct, but there was a stone wall which, if I hadn't pushed, we wouldn't have been able to achieve it. And that's one of the typical situations where I was doing as we were instructed, but the information I got was an email that said, you can't do it.
I think it's getting better, to be honest, Madam Chair. I think it's getting better. I think the establishment of the working group with WA Police, and I will mention Commander Panea, who's in charge of that firearm reform team. His team are doing a pretty good job trying to grip it up. They are making some policy changes on the run, given that they're not necessarily in regulations. So, in their defence, they are trying to engage, and it's not perfect, but it's a little bit better.
Okay.
Yeah, my question was around, like, from that example, was that a long time ago in the very beginning, or has that improved since then?
No, it was only 2 or 3 weeks ago.
Okay, no worries.
It was the information we received was back in March.
Yep.
And when and it's so important because we cannot operate our ranges and supervision without authorised people. We need to get it done. We don't need to wait for something as simple as the transfer of one authorisation from one licence to the transfer of another. And it was meant to be simple. It turned to be difficult. Now, hopefully, the regulator, when the next person tries to do it, won't meet a brick wall. But we're not sure about that.
There's one here, and I think it's the WA Shooters Union. So, Steve, Mr. Harrison, on here you talk about interstate licences, non-recognition, and I guess it's two-pronged because it's talking about people coming from another state in, and then licences not being recognised. So I'm not sure, I don't know, but whether they're firearms, whether they'd have to get rid of them when they move here or how that is. So I'll ask you that. But then the sporting side of it, I guess, if that affects sporting
So what I
shooters.
can do is I can introduce Royce to the committee. Royce is a guru on the national position, which is, I think, will assist you substantially.
Yes, if I can speak to that, Mr. Caddies. Coming from what we were referring to in the submission is an instance where a sporting shooter from one of the other states in Australia wishes to come to Western Australia to participate in a competition or go hunting. Under the current legislation in Western Australia, the previous one and the new one, our licences are not recognised. So essentially, as soon as we cross the border, we are deemed not to have a firearms licence. Whereas if somebody from Western Australia wishes to come over east, there are provisions in the legislation, certainly in Queensland, which is the one I can speak best to recognise licences from other states for approved purposes such as competition shooting, hunting, and a few other limited uses. So somebody coming from Perth to Brisbane to compete in a competition, their licence from Western Australia will be recognised in Queensland for the purpose of that competition. The reverse is not true, and this has very serious issues for hunting and shooting in Western Australia, because the requirements to legally bring a firearm which is lawfully owned elsewhere into Western Australia are quite onerous and very off-putting. If I, for example, wish to attend a shooting competition in New South Wales, my licence is automatically valid. I can just place my guns in the car securely in compliance with the storage legislation, drive to the competition, participate, turn around and come home. I don't need permission from New South Wales Police. I don't need to apply for a special temporary visitor's licence. I don't need to tell them which firearms I'm bringing. So all these things are currently not available under the existing or previous Western Australian legislation. So we are very much of the view that needs to be changed to ensure national consistency.
And if I may, Rod, what we see is a severe limiting of events being held in Western Australia, national events. So West Australians, by and large, in the competition environment, travel out of Western Australia and go to the other states and territories. But if we try to hold a national competition, and Murray may be able to speak to this a little bit more, if we try to encourage national competitions in Western Australia, interstate competitors are reluctant to come. Not only the tyranny of distance, but the barriers to entry. It is really quite onerous to be able to get a gun into Western Australia because you're licensed in another state and come and shoot or host a national competition here.
If I might provide just a illustrative example, or sorry, a comment on that. At the moment, my Queensland driver's licence is valid here in Western Australia. So if Mr. Harrison here wished to lend me his car while I was visiting, that is completely legal. However, my firearms licence from Queensland is not valid, so I cannot touch any of Mr. Harrison's guns. We cannot go hunting together. We cannot go to a clay target range together. So it does seem very strange that my driver's licence is fine, which lets me operate several tonnes of motor vehicle on a public road, but I'm not legally allowed to take a side-by-side shotgun and break some clays.
Because we just don't have a national firearm licence.
Yeah, I can reiterate that. I mean, it is affecting competition. Recently, there was competitors coming to WA who were restricted by the numbers of firearms, the limits on the firearms they can bring, which is an issue. We just currently had a junior whose parent in New South Wales had a licence for 2 years. Of course, when she came here, she could bring the firearm, the permit, into WA, but she couldn't supervise him under our legislation. So I needed to get a permit to enable me to supervise him. Once again, a volunteer, but I need to spend the time if we want to attract people to our state. It's difficult and it needs to be made easier.
If I may just add one more comment. We've got a lot of tourists that move through Western Australia from other parts of Australia, and I think they unknowingly are driving their caravans and camper vans into Western Australia in possession of firearms, not knowing that they are about to be hit with a very, very serious penalty. That, I think, is unjustified in as much as they are licensed within their own state and they are lawful within their own state. So that's quite a dangerous outcome, and I would suggest there'd be some volumes involved in that as well.
Okay, that might be a question we'll ask WA Police whether that's translated into, Are you finished with that? Yeah. Can I just ask, so beyond the individual shooter, I guess about clubs and what the impact on clubs has been, and in particular, do you know of any clubs that are at risk of closing down?
I'll kick that off if I may. That's kind of our domain, Murray and myself. When this all kicked off, there was a bit of a campaign from WA Police to do desktop reviews of approved shooting ranges in Western Australia and see where the combined failure of the regulator and, in some instances, the operators over the last 30 years had resulted in immediate assessment of danger to the community. So there may have been housing put into a danger template. In one instance, at one of our complexes, a mountain bike track was put through what would be considered to be the danger area where a projectile might land, etc., etc. That has tempered off somewhat, and it's our understanding that there's going to be a much more conciliatory approach to how, instead of the sledgehammer, there's going to be a bit more of an approach by WA Police to work with the clubs and ranges to mitigate immediate risk, but allow them to continue to operate. And it might be reduced calibre sizes that they can use, etc., etc. And it was only last week evidence has been brought to bear on that the Jarrahdale SSAA range was reopened with a transitional authority. So that took us a year to work through that, and more importantly, the volunteer members of that club. You might also be aware we have another firearm club at the top of Armidale Hill called the Southern Districts Rifle Club. The new police minister, Reece Whitby, did reopen that some months back. That club, as a group of individual members with 400 or 500 members, exerted $180,000 worth of moving of dirt to get that club reopened. There is no government funding for that. There is no community grants. Those 400 people spent $180,000 to get the dirt into a position that WA Police were happy with that, and new fencing and making sure that a backpacker doesn't wander through the Jarrah forest and walk onto what is clearly marked an approved shooting range. So we've had lots of engagement with the regulator about that from an SSAA perspective to make sure that the construction of the Firearms Act was forcing people to go and join gun clubs who thought that they could park their firearms in a gun club. It's not that simple. It's a bit of a process to go through. And the clubs were going to burst at the seams. And if you pressure the local footy club and, they've been the coach for 10 years and now they've got an additional 100 players that want to come and play, they don't want to do it anymore. So it's backed off a little bit. I am part of the national approach to civilian range design with the Sporting Shooters Association. I'm engaged with the South Australian Police, which is where that's driven from. And it kind of filters out from a national group of police agencies about how we are going to nationally look at range danger areas. And we have subject matter experts on ballistic capability and military range danger templates in Australia. And everybody's all come together, working with South Australian Police and WA Police now to interrogate a cohesive approach to modern firearm range construction, rather than just sitting in a desktop and saying, that one looks dangerous, we'll turn that off. So I'm quite comfortable as the association representative at a state and national level that SSAA is at the forefront of civilian range danger mitigation, and police from both states, and evidenced in the other regulators in New South Wales, Victoria, Tasmania, etc. There is no urgency or immediate public safety about what happens at approved gun ranges at this point.
Thank you, Mr. Bowe.
Chair,
Yeah,
Club-
no, come
We
to
are starting to see a reduction in our membership numbers due to the cost and the limitations on the numbers of firearms and the cost involved in retaining them security-wise, and Paul touched on that, unoccupied, occupied premises, etc., and the difficulty of understanding it. It's easier just to give up the sport. We're now starting to see clubs, as a result of this, making inquiries about how they can close their clubs down. And that's a pity. They're mostly country clubs, small country clubs. And this, of course, it's also the conditions on getting your licence now, health checks, the mental health aspects. And I think we forget, we look at all the negative sides possibly of mental health and firearms. But what we should be looking at is the positive aspect of firearms on mental health, because it's an outlet, it's a sport, and it's what people do. And as I say, we're starting to see clubs asking about how they can close down, and that's really disappointing.
Okay.
only to say, and a segue into that anyway, because one of the things that have emerged in all the other hearings is this mental health question, but I don't think I heard it mentioned apart from Mr. Bowe just now. So I know you give people the opportunity to make any new points in their closing remarks. I wouldn't mind hearing something in those final points, anything they might not have mentioned about mental health.
Okay,
Thanks.
No, Rod, do you have any further questions? No? All right, well, given the time, then I might invite you to make any closing remarks, and as my colleague pointed out, if there's anything that you wanted to say that you haven't had the opportunity to say, or any final points that you'd like to get across. And yes, as Simon points out, we are here today to hear about shooting as a sport. So, yeah, anything you want to tell us about the benefits of participating in a sport.
I'll say a couple of things.
Oh, sorry, I've covered it.
Yeah, on mental health. So I'm a veteran. I represent a veteran firearm owners club. Certainly veterans are concerned about the way police are going to tackle, or the regulations are going to tackle the mental health issues. Because we do have guys with PTSD and some may be on mild forms of medication. That doesn't mean that they're potentially violent. It means they have an injury from their service. So for guys to get together, guys or women, ex-servicemen to get together, whether they go to a shooting range, they're engaging with people, so it is good for their mental health. It's good if they're going out into the country and sitting around a campfire and shooting a couple of feral animals, being foxes or cats. So that's helping the community, the rural communities. So that is a couple of examples of mental health benefits to the sport. Like any sport, cricket, soccer, whatever, you are engaging with like-minded people. I have already mentioned about the very low crime rate for firearms ownership, so that needs to be considered in those statements. That's all I have to say. Thank you.
Thank you. Thank you for your statement, and thank you for your service.
And thanks for the opening about mental health, because I do have a note about it. And the issue of mental health checks, it's raised concerns with the focus of mental health being an issue with one's ability or suitability to have a firearms licence. What's been missed, and I see it as a coach and a mentor of junior athletes, is the benefit of recreational and competitive shooting to an individual's mental health. We need to respect that participation in recreational shooting and competition has many positive aspects. Shooting is a skill, and there's some words here which people may not associate with shooting, but it engenders safe, responsible and non-aggressive behaviour through the learning of mental skills and personal discipline. That's what shooting does for people. It's extremely important for both young and older participants, providing self-discipline, mental development, emotional control, increased concentration, enhanced attention skills and motivation, all positively contributing to a positive mental health. And these are not my words. This is research done by psychologists on the benefits of pistol shooting and rifle shooting and any competitive shooting and any shooting at all. I don't know why we're so negative. We should actually be seeing the positive when mental health and firearms are mentioned together.
Thank you.
And could I just sum up, and this will be the last you hear from me?
Yep.
We as an organisation, we support the regulation to have public safety as a central principle. It should be consistent with the National Firearms Agreement. It should also be consistent in its application to facilitate shooting sports and firearm-related activities. We believe the legislation should be rewritten with substantive provisions put in the Act and the minor provisions in the regulations. But all of this, as mentioned before, should be supported by proper consultation and evidence. Thank you.
Mr. Fitzgerald.
Thank you, Madam Chair. So just in closing, I think that instead of what happened with the health professionals being segregated by the previous construction and the end users, the likes of the Sporting Shooters Association, my recommendation would be to the committee that moving forward, that the Royal Australian College of GPs, the Mental Health Commission, the likes of the Sporting Shooters Association get in the same room rather than the police talking to the doctors now not being too happy about what the police have suggested, and 80,000 people who are the people with the actual firearms are not in the conversation. We should be able to, as a collective society, mature, put the doctors with the regulator, with the end user. bring those three groups together so that the end users can talk to the Royal Australian College of GPs, for example, and say, this is our contribution to how we should ensure public safety with a health assessment. I think, with all due respect to Mr Ehrenfeld, the mental health assessment was a bit of political rhetoric when it was kicked off by the previous police minister, and it's now being referred to as a health assessment. This mental health component, without playing it down, it's moved towards a health assessment, and that's where we need to really keep it. It's an overall health assessment. It's not just about mental health. And we need to get the end users, the professionals, the people that you've bore witness from, who've got concerns, because 1 in 10 GPs don't want to do a health assessment if it's got the word firearm attached to it. And we need to get the people that have actually got the firearms to have their contribution in the same room.
Okay.
Thank you.
Thank you. Thanks, Mr Fitzgerald. Mr Harrison.
Thank you, Madam Chair. I appreciate the opportunity to speak again. In relation to mental health, and I think it's something that we should all be concerned about in our community because it seems to be increasing. In respect of firearm owners and mental health assessments, I don't believe that a person who is a firearm owner or an applicant for a firearms licence should be thrust into a mental health assessment on the basis of it makes up part of the assessment process. I think it's a waste of resources. It is a total waste of resources. You've got doctors who are saying they won't conduct mental health assessments on people. The nature of medical facilities these days, particularly GPs, is they work in leased premises, so they lease a room and they move on every 6 months. I've had that experience myself. There 1 minute, gone the next. So you go back to that practice, and although the practice is familiar to me, the doctors are not. So are they going to be willing to provide a mental health assessment of me, which is only relevant at the time of the assessment in any event? So I'm a veteran police officer in Western Australia, some 40 years. I've dealt with a lot of people and a lot of very compromising situations. And my view is this, is that we are all entitled to be a little upset sometimes. That doesn't necessarily trigger the need for a mental health assessment in real terms. And I think that it's a bit why the ambulance service works, is that you only get an ambulance if someone calls on your behalf, for instance, if you fall off your motorcycle and break your leg. So what I'm saying there is if there's obvious signs that a mental health practitioner needs to be brought into this person's life, then the people around them should then normally, and they do, just make that announcement. And that's the way it should be run. Why are we fishing through what could potentially be 89,000 licence holders in Western Australia, and we're fishing for a mental health problem so we can prove that the need for the assessment was there in the first instance, when clearly it was not.
All right. Thank
Thank
you.
you.
Thank you. And I say again, thank you all very much for attending today, and thank you as well for the work and the effort and the expertise that's gone into your submissions. I appreciate, particularly for member organisations, you've spent a lot of time gathering information and the perspectives of your members and your stakeholders as well. So on behalf of the committee, I thank you very much for that as well. If we could please end the broadcast. All right, so